All right. Good morning, everybody. Welcome to Enabling the Next 50 Years of Space Law, a multi-jurisdictional proposal. We will be having Charles Lee Mudd Jr. speaking to us today. Charles Lee Mudd Jr. is the founder and principal of Mudd Law. For over 20 years, he has focused on intellectual property, the internet, and technology law, becoming one of the foremost thought leader in these sectors. Over the last several years, he strategically placed his firm to provide critical advice and counsel to actors within the emerging commercial space economy, the aerospace industry, and the broader astro sector. His policy work in this area has included participation in United Nations, conferences on space laws and policy in Moscow, Istanbul, testimony on regulatory proposals at the federal level, and development of sound strategies for the future of space exploration. In 2020, he was elected to the International Institute of Space Law. He is also a member of the European Center for Space Law, the American Astronomical Society, and the American Institute of Aeronautics and Astronautics. He serves on the board for New Space Chicago. Welcome, Mr. Mudd. You may go ahead.
Thank you so much for that very nice introduction. What I want to do is to take a step back and think about where we're going to be over the next 50 years. And I think where we should begin is to kind of start looking back in the last 50 years, not in depth right now, but as an overview to kind of see how the laws developed, where we are, and then we'll move to some of the current issues, some of the emerging issues, and we'll talk about what the best strategy is for planning the next 50 years of space law, or at least my thoughts. And I hope to remember to say this at the end, but I welcome comments. I encourage collaboration and communication with me and others. So let's begin with the United Nations Space Treaty origins. There are two treaties that kind of led to the impetus or to help lead the foundation for the Outer Space Treaty, which I'll get to in a moment. The first is the Antarctic Treaty in 1959. Now, many of you, if not all of you, may understand that the Antarctic Treaty served as a foundation for the Outer Space Treaty. But if you haven't recently, I recommend taking a look at that particular document, comparing it to the Outer Space Treaty, and you'll see the acute similarities. One of the key foundational principles that happen to be included is the use for peaceful purposes. As we all know, we want to continue to use space for peaceful uses, peaceful purposes, and that underlying principle began with the Antarctic Treaty. There was also in 1963 the Limited Test Ban Treaty, focused on not using the atmosphere, outer space, or water for nuclear tests and so forth. So with that foundation, we lead to the core five space treaties. When we talk about space treaties, these are the five that most people consider. Some, in fact, I'm actually in Paris right now at the International Astronautical Conference by the IAF, and I heard a speaker the other day identify the Limited Test Ban Treaty as one of the United Nations space treaties. And I understand where that's coming from as far as a core concept. And yes, it does involve outer space, but really the core space treaties are these five: the Outer Space Treaty, the Rescue Agreement, Liability Convention, Registration Convention, and Moon Agreement. You can see the years there, and the one year that I want you to focus on is 1984 for the Moon Agreement, and we'll come back to that in a moment. But I'd like to start with the Outer Space Treaty as the core, the solid. If the Antarctic Treaty and the Test Ban Treaty, let's say, are the bedrock, then the Outer Space Treaty is the foundation and the structure from which all others kind of emerge. They set out and lead out the principles that the other treaties and really the other documents that we'll get to stem from. So the Outer Space Treaty has a number of principles. I'm not going to dive in here, but that's a key document. And the rescue agreement provides for the fact that all of the nations signing on to the rescue agreement will lend aid wherever possible to astronauts that are stranded or in need of help. And that principle expands upon language from the Outer Space Treaty, as does the Liability Convention. There is language in the Outer Space Treaty that makes it clear that the launching state is ultimately responsible for any object, any harm that comes from an object that's launched from its jurisdiction. The Liability Convention expands on that to a great detail and provides for strict liability where harm occurs on Earth to either persons or property, to the launching state, and then conditional liability where there's harm in space. So, for example, if a satellite collides with another satellite in orbit, then that is a conditional liability determining who's responsible, investigating, and so forth. Where the harm occurs on Earth, there's strict liability. It also talks about joint and several liability, and that is when, of course, there might be multiple players involved and 2 or 3 countries might be involved in a particular endeavor, and their conduct, their activity causes harm to a third party. Then those that were in collaboration, working together, those state parties, launching states still, but those state parties, the liability would be joint and several between them. The Registration Convention provides that, encourages countries that are a party to it, requiring them to, I guess, let me take a step back. In principle, the Registration Convention is encouraging everybody to register the objects that they launch. And those that sign on to the Registration Convention in principle agree to do so. And finally, the Moon Agreement. Now, the Moon Agreement expands upon what might arguably be ambiguous language in the Outer Space Treaty. There might be some parties that would argue that the Outer Space Treaty provides that that encompasses resources, where the Outer Space Treaty declares that no party, any entity, any government can claim ownership of a celestial body. There's an ambiguity as to whether or not that includes space resources. So if we mine regolith from the moon, there might be some people that would argue that the Outer Space Treaty prevents ownership of the material mined, but it's ambiguous. And I am one that believes that the Outer Space Treaty does not include specific content like rocks or regolith or other resources from the celestial bodies. The Moon Agreement, of course, resolves that ambiguity and makes it very clear that you cannot claim ownership of anything obtained from a celestial body, resources, rocks, whatever, and all of that needs to be shared with everybody. Not surprisingly, as you may know, the Moon Agreement has not been agreed to by the United States. So really, for an example, if we're looking just at the United States, it has been nearly 50 years since the last space treaty came into force to which the United States belongs, 1976. As far as globally, looking at those 5, it's 1984 with the Moon Agreement. Now, as of now, there are 112 countries that have ratified, accepted, or approved the Outer Space Treaty, and you can see the numbers moving across, pretty consistent between the Rescue Agreement and the Liability Convention, 72 on the registration, and only really 18 with 4 signatures of the Moon Agreement. So beyond the agreements, beyond the treaties, actually, we have United Nations principles, and there are additional documents that do not have the same force as the treaties, but nonetheless are United Nations documents governing what's going on within terms of space. So Declaration of Legal Principles, Broadcasting Principles, Remote Sensing, Nuclear Power, Benefits Declaration. There are also additional documents that we could get into and discuss, but we're not going to do that right now. 2 that I do want to mention are space debris mitigation guidelines, and of course, the most recent guidelines for the long-term sustainability of outer space activities. So within the construct of what we have on international, from a UN perspective, we have the treaties, we have other documents, declarations, principles, we have guidelines. Now, from there, let's look at what do we consider to be space law? What should we encompass within that? Well, we've went over some of what we've talked about. We've gone over some of what we would argue falls within international space law, the treaties, the declarations, guidelines, and so forth. Then within each country, there's the domestic space law, the efforts to ensure that those parties, not only within the government, but those parties regulated by the government, comply with the terms of the treaties and the documents to which a particular country is assigned. So under those treaties, there is the obligation of the relevant state parties to govern themselves and other parties in their jurisdiction under the same course or laws. So that's where we have a number of laws within the United States, for example, that are consistent with those treaties and implementing a lot of the terms that we've talked about, or the laws generally that we've talked about. Now, what I also do is split this up further into, so domestic space law, law specifically focused on space, non-terrestrial matters. There's the nuance law, and really I should have nuance law and regulatory regimes somewhat reversed. The regulatory regime are those regulatory agencies and regulations focusing on space. They don't have to exclusively focus on space, as is the case in the United States with the Federal Communications Commission, with respect to the Federal Aviation Administration, the FAA regulating the launch and reentry of vehicles, the FCC regulating communications with the satellites, but much more than that. But nonetheless, there are regulations that are specifically focused on space. And then nuance law is a subset or a separate category of those laws that might have application to space or do have application to space, but they're not space specific. Now, of course, with the commercial growth in space, there's traditional law such as contracts and other substantive areas that would apply. So this is kind of my breakdown here of the intersection of laws that are relevant to space. When we talk about that within the United States, for example, and who's involved, we have Congress and congressional committees, the National Telecommunications and Information Administration, which actually falls under the Department of Commerce, the Department of State, and ITAR, the International Traffic in Arms Regulations, the Department of Commerce and the Export Administrative Regulations, the FAA, which I mentioned, NOAA, with the Earth Sensing, for example, that's the National Oceanographic and Atmospheric Administration. We've got the FCC and its electronic filing system. We've also have regulations.gov, which is where you can find the regulations across the regulatory agencies. The FCC has its separate ECFS. There might be some overlap with regulations.gov. But in looking at all of this, and there's a point that I'll get to here in just a tad, just a little bit, and looking at all this, we can see that the regulation of space is scattered across a number of agencies. And even within the congressional committees, we haven't identified the actual committees themselves. Beyond the United States and any other spacefaring country or a country that's wanting to be so or have satellites, there will be similar structure to some extent, or the existence of those agencies, right? The countries will have agencies and laws that are doing the same thing that the United States is doing. And what I mean by that is implementing the international law and regulating space activities, albeit not necessarily in the same manner, in the same structure, or in the same specific laws. In fact, some countries, as we saw, 18, have signed on to the Moon Agreement. And then there is the United States, Luxembourg, Japan, and UAE. I believe I've hit them all, that have actually implemented laws completely contrary to the Moon Agreement. So with that background and the overview and the structure of space law and so forth, then let's talk about some of the continuing issues that we have. And I believe that throughout there has always been the concern that space is used by state parties, the countries, and those subject to its jurisdiction and regulation for peaceful purposes. Now, one aspect of this that's come up recently and has occurred over time, so it's not that, I guess I need to clarify that the issue hasn't arisen recently, but there have been developments that are recent with respect to it, and that's ASAT, anti-satellite testing. Typically, for those that don't know, but I imagine that most all of you do, that would be an instance where a country is testing whether or not it can shoot down perhaps a missile, or whether it can destroy a satellite, anti-satellite testing. So ASAT ban means that we would not do that. And you may have heard recently that India has done that, Russia has done that. And the problem, beyond merging into that militarization of space, is the creation of large amounts of space debris. So ASAT conjunction events create a large amount of debris that create any number of other issues with respect to space domain awareness, traffic management, and so forth. And some people point out that, and they might say, well, the United States has also done an ASAT. Well, the one instance that I'm aware of when the United States shot down a satellite or destroyed a satellite is where the determination had been made that the satellite would break through the atmosphere, go through the atmosphere, and actually cause harm on Earth. And so the point there was to avoid that terrestrial, that Earth harm, remember, where there would be strict liability, and the option then was to destroy it before it reached the atmosphere. Now, with all of these principles and issues that we're going to be talking about, there are always caveats and exceptions, and that's one of the things that we need to keep in mind. But nonetheless, the principle for an ASAT ban is we are not going to engage in that activity to essentially destroy satellites in orbit and create that debris. April 18th, 2022, Kamala Harris, our Vice President of the United States, announced this. It was designed to influence the United Nations Open-Ended Working Group, or the OEWG, and that actually has just met subsequent to that time. And since then, since earlier this year, In April, the countries Canada and New Zealand have also agreed to the ASAP ban. Now, that kind of leads next to the Artemis Accords, right? Where countries are agreeing to terms with one another that are not necessarily a treaty. And as I'll talk about shortly, as we talked about, the length of time since the last treaty, nearly, 46 years for the United States with the Registration Convention, 1984. So about 38 years since the last actual treaty, the Moon Agreement. The odds of a new treaty occurring anytime soon are slim. I'm not going to say some to none. I'm not going to say none because I think it's possible, albeit slim. And I'd like to think that we should push for that, but I'll get to that shortly. So with the ASAP ban and just even talking about those three countries coming together, the Artemis Accords is another instance where, pushed by the United States, there's a list of principles that have been developed and articulated in a document to which a number of countries have agreed, and you can see them here on the screen. One of the key principles, as you see on the bottom, is united for peaceful exploration of deep space. Now, the Artemis Accords, of course, include the efforts of the United States to kind of reemerge and come to eventually, in the near few years, have an orbiting station around the moon, Gateway, and then eventually make our way to Mars, although that's some time off. So what are the Artemis Accords? Well, in large part, they repeat and they essentially reemphasize principles that come out of the 5 space treaties. And again, that foundation, the structure, the Outer Space Treaty. The first is peaceful purposes. Then we have transparency, interoperability, and emergency assistance. And what that basically means is that the interoperability means that there's an advantage to designing spacecraft, space connections, and so forth that are interoperable with one another, such that if Japan needs to rescue a United States spacecraft or vice versa, that interoperability allows that more acutely and quickly to occur. Emergency assistance, remember the rescue agreement, registration of space objects, reaffirming that and what's in the registration agreement, or convention, the release of scientific data, which is both in the Outer Space Treaty and re-emphasized particularly in the Moon Agreement, although of course we're not agreeing to all of the Moon Agreement terms in the United States. Well, the United States has not agreed to any specific terms in the Moon Agreement, but a lot of the Moon Agreement repeats terms that have already been agreed upon elsewhere, if you follow my meaning there. What I don't want to say is the United States has not specifically said, we will agree to this in the Moon Agreement, but not that. Officially, certainly in negotiations that might have occurred, but there are principles, as I said, in the Moon Agreement that are reflected elsewhere that we have agreed upon. So then the next, we kind of start to expand into principles that may not necessarily be in those prior space treaties, one of which is to preserve outer space heritage, meaning that if there is there are locations on the moon where there have been landings of humans, to preserve those sites, that there's a sanctity to those sites. There's also section 10 talking about space resources, and you will see that in number 1, the signatories note that the utilization of space resources can benefit humankind by providing critical support for safe and sustainable operations. And then we add 2, where the signatories emphasize that the extraction and utilization of space resources, including any recovery from the surface or subsurface of the moon, Mars, comets, or asteroids, should be executed in a manner that complies with the Outer Space Treaty and in support of safe and sustainable activities. The signatories affirm that the extraction of space resources does not inherently constitute national appropriation under Article 2 of the Outer Space Treaty, and that contracts and other legal instruments relating to space resources should be consistent with that treaty. So the long and the short is it's emphasizing here the principle that they can extract resources and be consistent with the Outer Space Treaty. You will note that there's no reference to the Moon Agreement. Section 11 talks about deconfliction, and there are a number of points here. Due regard and harmful interference. So we want to operate with due regard of others and their interests and avoid harmful interference with their activities and interests. The long-term sustainability guidelines are referenced from 2019. Due regard, again, harmful interference, emphasized a number of times. Communication and coordination to avoid harmful interference, creation of safety zones. And then there's orbital debris. And so requiring parties to plan for the mitigation of orbital debris and limit as much as possible, new long-lived harmful debris. So we have the treaties, we have those formal treaties to where countries are obligated, at least for example, in the United States, that is law here, and the parties signing them agree that they're obligated to the terms. You can always extract from a treaty. We have the principles and declarations and guidelines that come out of UN. We have other agreements between countries on various issues. That's kind of the international aspect. And then, that's state parties talking about governments. And we mentioned how those state parties have to also govern or address issues related to or govern those under its jurisdiction in the same manner. That has become more acute now since the growth of commercial satellites. And if we look here, this was pulled today, currently using space track, ephemeris or TLE data, we see that there are currently a total of 9,132 objects tracked, LEO 7,321, middle Earth orbit 566, middle Earth. Well, Lord of the Rings reference. That's what caught me up there for a moment. Geo orbit 826, outer 419, and what I mean by that's my own distinction. And they might be within the geo area, but just cutting off a cap, it was a sharp cutoff, and some fell outside what typically would be geo. And so that's what the outer is referenced there. They're probably in geo orbit, but just at the time in their particular orbit, based on the calculations, they fell outside that specific geo orbit. And then decayed objects. You'll notice that we also have Starlink 3,021 objects in low Earth orbit. Some other emerging issues then with this commercial growth that we should talk about is space debris. Now, obviously, space debris has been around, and in fact, the IADC, the Interagency Debris, if I can remember, Commission or Committee, IADC, and the UN both developed guidelines with respect to the mitigation of space debris some time ago and began those discussions, if no earlier or no later than the 1990s. And that's when the United States started to look into that through the White House and beyond. But it was only recently in the last few years that we've really had the Federal Communications come in and start to push for, not just push, but implement stronger and stricter mitigation guidelines, to where now for an applicant might have to demonstrate that the odds of colliding with another object would be 1 in 1,000 or 0.001. I'm not going to go into all of those guidelines. That's another presentation. We don't have the time for that. But the space debris is a continuing issue, but emerging here, I would argue, because of the growth in the number of commercial satellites. There's the extraction of space debris and ownership issues. And what I mean by that is, you've read some probably about companies or countries wanting to implement operations where they will go up into orbit and extract space debris, so that they'll capture that space debris either onto the craft. Some people have suggested and talked about pushing it into burn up in the atmosphere. Elsewhere would be to push it into the graveyard orbit. But in any case, doing something with that space debris. And even debris, though, remains owned by the party that launched it. So you still have ownership issues. It's not as though an independent company can go up and just collect whatever it wants to. There are these ownership issues under the treaties. The Outer Space Treaty even reflects that. Space environmentalism. This is a big impact for, or big subject for me. It's really my argument. It's space environmentalism. There was a paper recently by Andy Lawrence. I recommend it. But what I mean by that is that we need to view Earth's orbital space as part of its environment. That's necessary, and we should regulate it as such. And when we talk about space debris, in the sense that we're already regulating that, we are doing that to some extent, but some don't like that environmental term, but we really do need to look at Earth's orbital space as part of the Earth's environment and regulate it as such. There are a number of issues related to that, such as astronomy, the effect of the satellites on astronomy, Earth observation, radio astronomy, and so forth. Liability development. Now, we've talked about the liability arising under the Outer Space Treaty, and then also expanded upon with the Liability Convention. But what's interesting is when you think about the proposed growth in on-orbit operations, we can all think about on-orbit operations already, in the sense that when we go up and rendezvous with the International Space Station, that is an on-orbit operation when one vehicle is connecting to another spacecraft. You can remember, perhaps for some of you, with the space shuttle and the repair of the Hubble Space Telescope. So there certainly have been on-orbit or in situ operations in space, but the growth of this will occur significantly. You have any number of companies talking about endeavors such as refueling in orbit, the repair of satellites, on-orbit servicing, and so forth. How do we address the liability in those situations? How will that develop? Now, certainly under the treaties, the principles remain that the launching party is responsible. So the country, the state party that launches a spacecraft, a vehicle or satellite, whatever the case may be, is responsible for that craft satellite object. But if we go to just thinking about the space debris mitigation guidelines that have been developed, that's really with the concept that we're trying to avoid conjunction events. With on-orbit operations, we're actually anticipating the conjunction events where two objects will come together, hopefully not collide, but nonetheless, that's a possibility. So Do we need to adjust the liability issues? Do we need more specific or stringent parameters? Do we need different, like we have the space debris mitigation guidelines in the United States, 1 in 1,000 odds of intersecting with another satellite? Should that be stricter? Should that be greater? So that with the intent to conjunct with the intent to connect, that the odds of that going wrong are even, excuse me, less than the 1 in 1,000. So liability development in these unique circumstances, defining ownership rights of debris, property in space resources, ITAR and EAR. I mentioned before the International Traffic in Arms regulations and the Export Administrative regulations when we were talking about all of the varying agencies and aspects in the United States. Well, ITAR is related to the United States munitions list. And so what that means is that there are certain technologies that fall within, you're only seeing part of my hand. There's certain technologies that only fall within the United States munitions list. And if they do fall within the United States munitions list, that essentially means and requires that United States citizens are not able to share that technology or technical data related to that technology with foreign persons. ITAR is more strict than EAR, and the penalties for violating ITAR can be quite severe, with not only criminal but also monetary penalties involved. So any commercial space operation wants to avoid ITAR and EAR. Certainly when we're talking about it terrestrially, you can understand that, all right, we're not going to share the certain technology that falls within ITAR with our employees or contractors that might be from a foreign country. But we need to remember that that same principle, those same regulations can apply in space. So imagine that the United States has a satellite, a company has launched a satellite with technology that's visible to the naked eye, but it's in space and it falls within ITAR, the United States munitions list. Can that company hire a Norwegian on-orbit servicing company to reach the satellite and make repairs or to service it? And in so doing, observe the technology that would fall under ITAR in the United States munitions list. The argument, I would argue that no, you can't, because you are then sharing the technology with that foreign person. And so this is another emerging issue. Cybersecurity in space. I just did a small presentation with a colleague from the AIAA and out of Houston, Svetlana Hansen, and we talked about the growth in cybersecurity in space. Now, for those that are not familiar, in the United States, there's the NIST framework for cybersecurity. We're at 1.1 and they're working on 2. But NIST has also come out with guidelines for cybersecurity in space operations. That's a whole nother presentation. I'm happy to share that paper with anybody, but these are issues that we need to be thinking about. Dark and quiet skies, the effect of the satellites on astronomy, on the just general enjoyment of the dark and quiet sky. Do we want to get to a point where the satellites that we can see through solar reflectivity outnumber the stars? I mean, clearly they won't outnumber the stars, but they could outnumber the visible stars. And depending on the light pollution where you happen to be, that might be more acute than, let's say, in Chicago, versus that may be more acute. There would be more stars, obviously, that you'd be able to see in Yellowstone than you would be in Chicago. And so it's more likely that the number of satellites that could be visible would outnumber the stars in Chicago rather than in Yellowstone, where you're able to see the Milky Way and everything. I understand you all appreciate that, but I just had to clarify that. So what cannot work by itself? With all of these emerging issues, where do we go? What do we need to do? What can we see forward in the next 50 years? I would say waiting for a treaty to occur and solve the problems is something that will not work by itself, and we can't do that. Reliance on guidelines, recommendations, and thoughts. And that's not something that we can necessarily do. I see a question. I will get to that shortly. And we also can't rely on self-governance in industry. My background in law comes, as the very nice introduction conveyed, comes from technology and the internet. And we've seen over the years, I mean, I started the firm 21 years ago nearly, and had been engaged in internet law before that. And industry, not all of them, but many in the industry advocated for self-governance. We've got this down. We've got this under control. We don't need any regulation. And we've seen that that's not the case. We still have privacy violations. We still have companies doing things that they say they're not going to do. And we can't have antiquated regulations. Now, I'm not suggesting that the United States regulations are antiquated. In fact, with respect to space operations, there's been an effort among and across agencies to update and modernize them, streamline the regulations. The FCC has done this, the FAA, NOAA. So there is an effort to modernize the regulations, but one in particular that I think many people would comment needs to change given the growth in collaboration among people and companies and even countries with respect to space happens to be ITAR and EAR. ITAR and EAR are very restrictive and prevent a lot of collaboration that would otherwise be beneficial. Now, we can all understand the reason why ITAR and EAR might be there, the security aspects and so forth. I'm not disputing that, but there is some reason, some valid reason to look at those. Now, there are ways to get exemptions or licenses through ITAR and EAR, so it's not an absolute, but you have to go through the formal channels and get that approval. What do we need? So we talked about what cannot work by themselves. What can or what do we need? We need consistency. The Moon Agreement says you cannot own space resources. In the United States, 51 United States Code, Section 50914 states that you can. So now, again, the Moon Agreement is not obligatory to the United States, but consistency across space regulations as we as a global environment and Earth move into the future, we need that consistency. We need education. We need to educate people about the objectives and the principles. I was talking to someone from UNUSA, Yukiko yesterday, in fact, and about bringing in countries that are not yet spacefaring, that are not yet engaged in space operations, and encouraging them to be so and to think about that and so forth. And I had asked the question that I heard from others, a few others from other countries, where there was a suspicion of the United States and that the advocacy for, let's say, the space debris mitigation guidelines or regulations were an effort to restrict space and keep out other countries from participating, which I do not believe to be the case, but I happen to be concerned about that perception. And I think that, if I can say this, I think that Yukiko correctly stated that it's not that where there might be, and she couldn't affirm one way or the other what I had heard, but where there might be that perception, it arises more from a misperception, a misunderstanding of the intent and the efforts involved. And so how do we resolve that? Education, getting people involved can help clarify perception and eliminate misperception. Enforceability. We have the treaties. How do we enforce that among countries? Even in the liability convention, it doesn't provide for, not that it prevents, but it doesn't provide for private resolution. It requires any dispute to go through the state parties. So we have these treaties that we've agreed to, but how do we enforce them? And how do we enforce them in a meaningful way and a quick way between companies, between individuals and so forth, as the conflicts in space will grow and continue to emerge. If anybody's watched the National Geographic episode or series Mars, you saw that played out to a very good extent in the conflict that doesn't need to be there, but that could be there and was dramatized between research on Mars in one instance and commercial operations in another. And the question that the monkey and the elephant in the room was, what are you going to do about it? You're a million miles away from any kind of enforceable police and so forth. What are you going to do when there is a conflict? We need to think about those things now. Clarity and synthesis, that's what we need to arrive at. So the title of this was leading toward a multi-jurisdictional approach, but I think it's better a multi-jurisdictional and multidisciplinary approach that's obligatory on the countries, the companies, all of us. So we need to continue to develop guidelines as a foundation. We do need to push for a new treaty, whether that's encompassing or limited. We need to continue with international agreements, working together, albeit consistently, encourage industry best practice, modernize regulations, and collaboration. And collaboration is key. And as an example of this, I just think it's important to mention the IAU's Center for the Protection of Dark and Quiet Skies. Now, that is a very nuanced issue, but nonetheless, when we look at their intent with the SAT Hub being resources for those in astronomy, software tools, and so forth, Industry and Technology Hub, bringing industry and technology in to try to help the problem or address the problem, not necessarily agreeing always with the astronomers, but encouraging best practices, developing tools that companies can adopt, community engagement, and a policy hub, raising awareness in policymaking circles, the coordination of policy work by national societies and observatories, coordination again, facilitate proposals for new policy and regulations. So this is focused on that dark and quiet sky issue, nuanced issues, but nonetheless, it's bringing people together in a collaborative manner, and parties that would perhaps have antithetical objectives. Astronomers on one hand, satellite companies on another. And I will have an aside that I do believe that Starlink, in its effort to develop the technology, VisorSat, DarkSat, and then VisorSat, which I understand both have been abandoned and they're working on something different, but they have been engaged to try to resolve the problem. And for those that are interested, the IAU CPS does seek members right now, both contributing and affiliate. So building out what a multi-jurisdictional and multi-dimensional approach, this is where I wanted to get to, but I believed it was necessary to lay that foundation, and I hope you're still with me on that. And I'm not getting in too much in the details here, but this is my framework. This is, and not that others haven't advocated for it, but This is my framework for what we really need to be thinking about and doing for the next 50 years. We need treaties. We need to develop them. We need to strategize on them. There were comments from another individual that I spoke to here at IAC, where he indicated that, like even within UN COPUOS, it's a consensus requirement. And so you need to be very careful what you ask about. Do you come in with a treaty that's very nuanced, specific language? Or do you come in with a global kind of treaty that's going to try to address a number of issues at the same time? There's also declarations, principles, and guidelines, as we talked about, that we can continue to work on. But I do believe that the need for a treaty is there. And I do believe that we should continue to develop and strategize on that, but it can't be by itself. There should also be continued discussions in UNUSA, UN COPUOS, the legal subcommittee in the UN, deliberations, consensus, lobbying those countries. So, the great thing is that it is consensus. So as countries join UN COPUOS and become involved, they have an opportunity to make their statements. They have an opportunity to ensure that there's consensus or not agree and prevent that consensus from occurring when there's a principle that they can't, that's unacceptable to them. But we need to use these, and I believe UNUSA, UN COPUOS, the LSC has been doing a great job at that, but that needs to continue. And more people, more companies, more individuals need to be involved. UNUSA has conferences and opportunities for various parties to engage and be involved, and I'd recommend that you check out their website. International accords, similar to the Artemis, we need to continue to develop them, but it's not a limitation. We shouldn't be limited by them. We use to implement regulations and domestic law that we'll get to in a moment, such as right now, statutes, regulations, coordination of agencies. What is the agency in the United States that's going to be monitoring or addressing or regulating rather, on-orbit servicing? FAA is really the launch and re-entry of vehicles. The FCC is more the communication of the satellites once in orbit. The actual activities are not necessarily in either of those. The on-orbit servicing activities aren't necessarily fall within the FAA or the FCC. And in fact, there's some aspect of that we see already where the FCC has said, even though they've come out and promoted, yes, you should be thinking about cybersecurity, there are statements among some FCC commissioners, at least one, where they believe that the FCC is not the appropriate agency to be implementing cybersecurity regulations on satellites. And if not the FCC, who? That needs to be determined because cybersecurity, again, remains a significant issue. So we need to eliminate the confusion on those issues. We need to think of the future on orbit, moon, and beyond, which then, of course, leads us to a consistency of domestic law on these issues. And that's where international accords, going back to that, can help. And in fact, that can go both ways, bidirectional. The international accords, these agreements, can help be the growth toward a treaty in one direction and the domestic implementation in another. Industry, we do need to involve. We need to have their engagement and participation because we can't regulate in a vacuum. We need to know what's possible, and they should be transparent with us. They should adopt best practices. And in fact, as one that represents companies in the space industry, the space sector, I advocate compliance by design. Let's think about these issues in the design process so that we can preempt, or not preempt, that we can anticipate what the regulations might be. Be transparent. And in particular, like using the astronomy example, being transparent means to share the TLE data. so that if that's accessible and available to, for example, observatory operations, they can plan around that so that it minimizes the impact on the observatories. If there's a satellite going to cross in the field of view, close the shutter for a short time, that might be one option. Community engagement and awareness, we need collaboration and coordination. And the timing is now. We need to be doing this now. We need to think about it. We need to be focusing on understanding and the study. I also just presented a paper here at IAC on the work that I've done with respect to data calculations on the satellites. I was calculating the orbits of Starlink satellites across a list of historical observations of a particular observatory, DCAM in Chile, to see how many of those observations had satellites cross the path. And when the Starlink satellites began in May of 2019, but let's look at just November, from let's say November 2019, December 2019, the percentage was maybe 3 to 0.5%. If we look at November, December, January, we're at of 2020, November, December 2020, January 2021, we're at 5%, 4%, 5% respectively. So a jump in order of magnitude. And the reason that I wanted to dive into the data and the calculations myself is because if I'm an advocate as an attorney or trying to influence policy, I want to understand the effects, and I want to understand as much as possible so that I can articulate that. I use the analogy of representing a client and in a particular business. For me to be able to argue in litigation why something is or isn't, I need to understand the technology of my client's business practice as best I'm able to. And I think that's important for all of us. I am looking for partners, students, professors, commerce, corporations, anybody that has an interest in looking at this. I think that we need help on all of this. I can't do it all. I know that there are many people out there doing all of these things and working on it, but beyond just talking about, yes, we need a treaty. We need to be presenting the language, we need to be coordinating with each other and communicating. And that is going on, but we need to continue to facilitate that. And so I think by doing these, by hitting all these things, we can develop a strong body of law, a legal regime for the next 50 years. Now, I do have a couple of questions here. First one, how do these foundational treaties affect industrial processing of raw materials into a finished product on the moon by sovereign nations versus corporate? So I imagine that what you're asking is, how do these treaties affect, let's say, a company arrives on the moon, extracts raw materials and processes them into a finished product on the moon. And I would argue that under the Moon Agreement, whatever the finished product is, would not be able to be owned by any particular party. I guess the question is looking at the language, whether it would allow under the Moon Agreement, again, the United States and most countries are not a party to that, but whether the Moon Agreement would preclude the processing of those resources, because it does talk about the extraction of resources remaining the province and the property of everybody, that there's no appropriation of that, no national appropriation, and that needs to be shared with everybody and so forth. So that's an interesting question. But given the fact that the United States law basically says that you can extract space resources, and I think the Artemis Accords are trying to navigate in and saying we're consistent with the Outer Space Treaty. In doing so, given the United States law currently and the Artemis Accords, its perspective is that the use of the space resources and the ownership of the space resources, whether by a country or a corporation, is consistent with the Outer Space Treaty and it's really the Outer Space Treaty. The Liability Convention really wouldn't come into play there, nor would the Rescue Agreement or the Registration Convention. So I believe I've answered your question, and I think that you only really run into issues if somebody's a party to the Moon Agreement. But I think that the United States perspective is we can do what we want with what we mine, and we could transform it, and it's our product. You also asked another question and said, you answered an industry question. What is the most needed policy? And maybe you thought that I already answered that, but perhaps I elaborated now. What is the most needed policy sandbox for new tech companies working with Space Force in corporate efforts for space? And I'm not sure that I exactly understand the question, but I'm going to take a gander. I'm going to take a crack at answering that. And I would argue that the most important thing for new technology companies that are engaging in looking to space would be to anticipate where the policies and regulations are going to be. And I believe that if you operate on the principle of peaceful uses of outer space and sustainable space, and a space that we are respective of the interests and activities of all stakeholders, such as astronomy, other space science, indigenous people, the dark and quiet skies, that and avoiding collisions and so forth, that if we look at it that way, if we look at it as an environment, and how am I going to be the best citizen in that environment, that's the best approach. But I think that, what does that mean, right? I mean, you can ask, and I can sit and talk to a company or a client, and what does that mean? Well, it means that we need to make the safest product. We need to avoid, as much as possible, collisions or interference with other parties. We don't want a bright object. You know, there was a proposal recently of space advertising to where you'd be able to look up into the sky and see a brand name, bright lights. I mean, I don't know about you, but I that's somewhat horrific to me. And so we need to be good citizens and try to anticipate what does that mean in terms of regulations. And so 5 years ago, somebody might have said, well, I'm going to make sure that our control of the spacecraft is so accurate and so dynamic that we will be able to avoid collision down to 1/10,000th of a chance, right? 1 in 10,000. And that would be beating the 1 in 1,000 that is in the new FCC regulations. Likewise, not using really reflective material, but using material or developing material that would avoid the reflection, but not be too absorbing of the sun's rays and build up the heat. That's why DarkSat, Starlink, SpaceX moved from DarkSat, that design, because this painting the black made the satellite, the heat increase too much and was affecting the operations. I think the same thing, I believe the same thing occurred with the VisorSat, and so they're moving to some other model. So that's what I would suggest, is try to anticipate what the regulations are, and that's where it's a brain trust, sitting down and, you know, you kind of have a policy sandbox, and maybe what that can mean in terms of my thinking on your question and answering it, and I'm running up on my time here, is that there's a collection of what the best practices, what the ideals would be, right? Take, for example, privacy practices among companies. For a while, the EU data directive was the leading international regulation on data privacy. The GDPR in the EU now, the California CCPA is probably up there. But when I'm advising a company in the United States, what is the best privacy practice? Well, don't go with the lower tier, because then you're going to run into conflict with some of the higher tier. And so always look to the most stringent requirements or regulations, meet those, and maybe even beyond that, and you're planning for the future. We've got to develop a legal regime that is going to provide and protect for the interests of all parties, not the companies, not satellite companies, not any particular countries. The United States should not dominate LAO to the exclusion of other countries. No country should. It should remain the province of all humankind, and that means across countries. So how do we reach that? We need to work together to develop policies, and not just guidelines and directives and nice talk and yeah, these are the goals and everything. We need to have core solid regulations that are going to do that. But I think that another way to answer your question too is I think that governments can provide guidance on what tech companies should think about, right? Let's think about the cybersecurity. That's not just to prevent somebody from a rogue person getting a satellite and doing something and not necessarily intending to cause a collision, but doing something that does cause that collision. It's being a good citizen, but also these companies, these tech companies that are engaged in that, there's an investment there, and it's talking to them about protecting that investment. You just look at the launch of or not the launch, waiting for Artemis 1, and we don't want to launch when there's a risk not only of causing harm to somebody. I mean, if humans were on board, but we don't want to have the risk of losing that investment and having something go wrong. And so I think there's a way to appeal to the companies and protecting their bottom line, their investment, talking to the investors, the VC capital and so forth. And at the same time, using that, going to policymakers and explaining why it's important to have laws and regulations that protect all parties. Because, for example, even on astronomy, there is an economy to astronomy. It may not be as large as telecommunications, but there is. And do you want to risk losing that value? I think not. I hope I've answered your questions, and I really, really appreciate the opportunity to speak here. And again, turning back to CISA and the SCSA allowing me to speak in return again this year, I very much appreciate it. If you all have any other questions, please feel free to email me, and I will, if I can, get to my final page that is merely my information. Whoops, I went by it, didn't I? So let me just put that up as I turn it back over to the host. Thank you so much.
Thank you, Mr. Mudd, for sharing everything. For the participants, if you would like to join us for the next session at 9:50, it will start right then. But other than that, thank you, Mr. Mudd. Thank you for the participants, and have a great rest of your day.
Thank you.